Just because you suffered injury as a result of medical care and treatment by a doctor, does that mean you have the ability and the right to go ahead and bring a lawsuit against him seeking money as a form of compensation for your injuries? Would you like to learn the answer? Come join me for a walk through this neighborhood near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no. It is not sufficient for you to be able to go ahead and bring a lawsuit simply because you suffered injury at the hands of your treating doctor. Now let me explain. There may be instances where you are able to do that. But just because you were being treated by a doctor and now you perceive or you believe that you suffered some sort of harm and injury from that doctor's care, that does not automatically equate or mean that you have the ability to bring a lawsuit against that doctor. Now you might be thinking, wait a second, that makes no sense. You thought that automatically that if you suffered an injury while being treated and cared for by a doctor, now you have the ability to go ahead and sue the doctor for compensation, for money, as a result of all the injuries and harms that you suffered. It's a bit more involved than that. You can't simply turn around and say, hey, I suffered injury because I took this medication, therefore the doctor must be responsible. No, that's not how it works. Doctor told you to do X, Y, and Z. You disregarded part of his instructions. You only did X and Y, and now you still have the problem that you're suffering from, and you turn around and say, wait a second, the doctor treated me, but I still have all these problems. I want to go ahead and sue him. Can I do that? In most instances, the answer will be no, unless a medical expert determines that what your doctor did violated the basic standards of medical care and that violation, that departure from the standard of care caused you harm and injury. You see, in New York, we are required to show three things in a medical malpractice case. We have to have a medical expert confirm that your doctor violated the basic standards of medical care. It's not enough to say, oh, I know in my heart of hearts that the doctor was wrong and that's why I suffered my injury. No, that's not how it works. A medical expert has to look critically at the facts of your particular case and make a determination as to whether or not your doctor departed from the standard of care. If the answer is yes, the next question that has to be answered is, okay, was that departure a cause of your injury? It doesn't have to be the cause because there could be multiple causes. It only has to be a cause. If the answer is yes, now we have to go to the next question, which is, what injuries, what permanent physical harm and injury did you suffer as a result of the doctor's carelessness? Only if our expert confirms all three of those elements and now tells us, yes, the doctor was careless, he violated the basic standards of medical care, and as a result of that, caused you significant harm and injury. Now you have grounds to go forward with the case. You cannot start a lawsuit in New York unless and until we have confirmation by a medical expert that yes, all three of those elements are present. Just because you believe you suffered harm because of a doctor's care and treatment, that is not sufficient to go ahead and start a lawsuit in New York. That doesn't happen. And we cannot and will not be permitted to do so. Instead, the expert has to confirm with us that yes, he has reviewed all of your medical records. Yes, the facts reveal that the doctor did in fact violate the standards of care. And as a result of his departure from the standard of care, that caused you harm and injury. And we also need to know that if your treating doctor had gone ahead and treated you appropriately, you would not have suffered the type of injuries that you are now claiming you received because of his carelessness. All of those things are necessary to know before we are permitted to go ahead and file a lawsuit on your behalf. So don't think for a second that just because you suffered some type of injury or some perceived injury while under the care of a doctor or at a hospital, that automatically entitles you to go ahead and bring a lawsuit, because that's not the case. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if you have suffered injury while under the care of a doctor or hospital staff, and you're thinking about bringing a lawsuit but haven't done so yet, and your matter happened in New York, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.